Hello, my name is Sue Miller, and together with Ed Davis, I head up the Finance Litigation Group at Stevenson Harwood. Welcome to the first in our Autumn 2014 series of 4 short webcasts in which we take a bite-sized look at some of the key themes emerging from the courts over the last 12 months. Last year, Donna Newman, a senior associate in our finance litigation team, reviewed the court's approach to financial mis-selling claims. In today's webcast, Donna will be providing a brief recap and then reviewing the recent developments in financial mis-selling claims.
Hello. This time last year, we released a webcast on the court's approach to financial mis-selling claims in the court year 2012 to 2013. This short webcast provides a brief recap on this topic, as well as an update on the cases that have been before the English court in the court year 2013 to 2014. First, a brief recap. In essence, a financial mis-selling claim is a complaint by a claimant that they have been sold a financial product such as a bond or an interest rate swap, which they should not have been sold. In order to bring a successful claim, claimants must establish duty, breach of duty, and causation without relying on hindsight. The financial mis-selling cases can be split into 2 categories. First, claims by those classified under the FCA rules as private persons, essentially individuals and other entities not suffering their loss in the course of carrying out business of any kind. And second, claims by non-private persons, essentially corporate entities. The importance of this distinction is that under Section 138D of the Financial Services and Markets Act 2000, or FSMA, broadly speaking, a breach of an FCA rule is actionable at the suit of a private person, but not by a non-private person, who has suffered loss as a result of the breach. Thus, a private person can sue a bank on the basis of breach of statutory duty without having to show that the bank owed it a common law duty of care or that the bank acted negligently. Financial mis-selling claims by corporate entities, on the other hand, need to be founded in common law and so are often framed as claims for negligent misstatement and negligent advice. In making a claim for negligent advice, a claimant must establish, among other things, that the bank assumed a duty of care to them, and in particular, that the bank acted as an advisor, as opposed to just providing information about products on offer. Last year, we concluded that claimants making mis-selling claims in the court year 2012 to 2013 had faced significant hurdles, and the court had tended to find in favour of the bank. In the case of Zaki versus Credit Suisse, the claimant alleged that the bank had arranged lending that was not suitable and had breached its regulatory duties, in particular Rule 7.9.3 of the FSA Conduct of Business, or COB rules. The decision by the court in this case showed us that failings in the processes undertaken by the bank will not ultimately determine the substantive issue of whether the lending was suitable. The court found that the bank's approach to obtaining and recording customer information lacked rigour, but rejected the claimant's contention that these failures were critical and should alone render the bank liable for all losses arising out of a transaction. The 3 Camerata claims against Credit Suisse and the case of Basma Al-Sulayman versus Credit Suisse showed us that the court will look carefully and realistically at the case presented by the claimant and will not simply hold those with deep pockets liable to compensate investors who sought high returns at high risk. Camerata has so far not been able to persuade the court that it was, as it claims, extremely risk-averse, and the court found that much of Basma Al-Sulayman's case was simply based on a fiction. In these cases, the claimants have also struggled to prove causation, i.e. to establish that but for the investment complained of, the money would have been invested or held in such a way so as to avoid the occurrence of similar losses. In the Al-Sulayman and Zaki cases, the court found that the claimants would have invested in the same or similar products, whatever the advice of the bank, and so would have suffered the same losses. In the High Court decision in the case of Green and Rowley versus RBS, the court decided two important points. The first of these is that recommending a product is enough to constitute giving advice, and thus give rise to the common law duty of care not to advise negligently. However, a bank is not necessarily recommending a product simply because it is providing information about that product. Simply presenting various products to the customer and discussing advantages and disadvantages does not, without more, amount to recommending or advising. We said last year that it is not entirely clear from the case law where precisely the dividing line between providing information and recommending a product lies, and clarification from the court would be welcome. The Court of Appeal's recent decision and analysis in the case of Webster versus Mark Liddington may provide us with some further guidance on a bank's responsibility for the information that it provides to its customers. In this case, clinicians had given manufacturers' brochures for cosmetic treatment to prospective patients without any disclaimer. The court found that by doing so, the clinicians had adopted the information as their own, thereby taking on the same level of responsibility as they would have had if they had been the original maker of the statements in the brochures. Of course, the outcome of this case is highly fact-specific. However, its potential relevance to finance cases is illustrated by the fact that the court agreed with and adopted the test formulated by Mr. Justice Toulson in the first instance decision of IFE Fund versus Goldman Sachs. In Webster, Lord Justice Jackson explained that the test for determining the level of responsibility assumed by someone who passes on a third party's information is an objective one. The extent of the responsibility is that which a reasonable person in the position of the person receiving the information would A. understand from the words used by the party providing the information, or B. infer from their conduct and all the circumstances. The existence of a disclaimer will be an important factor. Thus, by analogy, if a bank provides a customer with information deriving from a third party, which contains statements or advice about a financial product or investment, it may find that it has assumed responsibility for those statements or for the advice. Whether or not the bank gives a valid disclaimer in these circumstances will affect the analysis of any claims. The second important point from the High Court decision in Green and Rowley concerns the relevance of a bank's regulatory obligations to common law claims. Green and Rowley alleged that the bank was in breach of the FSA's COB rules and that they had suffered loss as a result of the breach. Although in principle, Green and Rowley qualified to bring a claim against the bank for breach of statutory duty under FSMA, as they were private persons within the meaning of the statute, they accepted that they were out of time to do so. They therefore sought to argue that the bank's alleged breach of the COB rules should be actionable as a breach of a coextensive or concurrent common law duty of care. The High Court refused to use a bank's obligations under the FSA handbook to create a parallel common law duty of care which does not otherwise exist at common law. This aspect of the High Court decision was appealed. The Court of Appeal judgment of October 2013 approved the High Court's decision. The Court of Appeal rejected Green and Rowley's contention that the bank owed them common law duties of care, mirroring the content of the COB rules. The court said that Parliament had provided a specific remedy for contravention of the COB rules in the form of an action for breach of statutory duty, and that there was no feature of the Green and Rowley case which justified the independent imposition by the court of duties of care at common law. The court pointed out that this does not affect the long-established principle that once a bank has undertaken a common law advisory duty, the required standard of care under that duty is informed by the relevant regulatory rules. This year, the court has also looked at the question of limitation with respect to financial mis-selling claims in the case of Kay's Hotel versus Barclays Bank. The standard limitation period for such claims is 6 years from the date on which the cause of action accrued. In this case, Kay's Hotel brought a claim in respect of an interest rate hedging product that had been sold to them in 2005, which they alleged had been unsuitable and had not met their wishes, intentions and needs. Barclays sought to have the claim summarily dismissed on the grounds that it was time-barred because the claim had been issued some 7 years after the product had been sold. Kay's Hotel accepted that their claims for breach of statutory duty and breach of contract were out of time, but in respect of their claim in negligence, relied upon Section 14A of the Limitation Act 1980 in order to claim an extended limitation period of 3 years from the date on which they had knowledge of the material facts about the damage. Barclays said that Kay's Hotel had had sufficient knowledge for these purposes from December 2008, when they were required to make payments to the bank under the interest rate collar, and therefore, even using the date December 2008, the claim was still out of time. The court disagreed. It said that the essence of the complaint was that the product had been missold because it carried excessive risk over the life of the product. The court therefore refused to find, at least summarily, that Kay's Hotel had acquired the requisite knowledge by December 2008 simply because they had made some payments to the bank for a period of about a year. Instead, it held that Kay's Hotel had a real prospect of relying on Section 14A of the Limitation Act so as to defeat Barclays' case on limitation, and that final determination on this point would require a full factual picture. This case will provide assistance to claimants for claims in negligence, where a product was sold to them more than 6 years ago, but where they only acquired the knowledge required to bring the claim within the preceding 3 years. It is important to bear in mind, however, that it is only a first instance decision on an application for summary judgment. Furthermore, the date on which knowledge was acquired is often not black and white, as illustrated by the case of Kay's Hotel, and claimants seeking to rely on an extended limitation period can expect to face a detailed examination of what they knew or ought to have known throughout the relevant period. In summary, as noted in our webcast last year, the financial crisis provoked a high volume of financial mis-selling claims. This batch of cases can be expected to diminish, not least because unissued or recently issued claims will start to face limitation issues. However, there are still a number of these types of cases making their way through the courts, and there may be others that follow as a result of the decision on limitation in Kay's Hotel. The decisions of the court so far have shown that these types of cases are not easy, and a number have failed where claimants seek to recover losses arising out of the financial crisis, but ultimately cannot make out the constituent parts of a claim. The coming year will no doubt see some further developments in the law on financial mis-selling.